The U.S. Supreme Court has just issued a new unanimous ruling in favor of a white straight woman who was, at least allegedly, discriminated against at work. This new ruling of theirs opens the door wider for these types of reverse discrimination cases. Basically, cases where the person getting discriminated against is part of the quote-unquote majority group. Let's go through the details of this case together, as well as what this ruling means for all of us moving forward. And of course, if you appreciate content like this, do take a quick moment to smash those like and subscribe buttons so that this video can reach ever more people via the YouTube algorithm. Now, to start with, one of the most prevalent themes over the last, let's say, decade has been the ideology of DEI, which stands for Diversity, Equity, and Inclusion. It was exactly this push towards DEI which saw some truly amazing situations come about. Like this one here, showing that in the year 2021, the 100 largest companies on the stock market gave 94% of their new jobs to people of color. Likewise, you had situations like the one out in the state of California, where they passed two separate laws which created a quota for the number of women, the number of minorities, and the number of sexual minorities that you need to have on your corporate board. Meaning essentially that during your actual job interviews over in California, you had to take into consideration the applicant's race, their gender, and their sexual orientation. And then you had another case that took place over in the city of Minneapolis. The teachers union there, they reached an agreement with the school districts which made it such that white teachers must be laid off first regardless of their seniority. According to the contract that they negotiated, the one that the teachers union signed with the local schools, it stipulated that if a school had to lay off teachers, it will be done so in order of seniority, except if that teacher is a, quote, member of a population underrepresented among licensed teachers. Meaning in practical terms, that if the school district was planning to fire a black or a Hispanic teacher, they had to stop and instead fire the, quote, next least senior teacher who is not a member of an underrepresented population. And so situations similar to these came up across the whole country. However, if this type of thing sounds patently illegal to you, you're not alone. Many white straight applicants or employees who felt that they were discriminated against filed lawsuits. And despite those lawsuits taking a long time, quite a few of them are beginning to bear fruit. Now, the one that I want to highlight today concerns Miss Marlene Ames over in Akron, Ohio. Here's her story. Quote, Marlene Ames, a straight woman, has been employed at the Ohio Department of Youth Services since 2004. She started off as an executive secretary and after repeated promotions became a program administrator. Okay, so far, so good. She's been working there for roughly 13 years. She started off as a secretary and slowly moved her way up to program administrator. All was going well until she applied to be the bureau chief. Quote, in 2017, she began reporting to a woman who identifies as homosexual. She applied to be promoted to the position of bureau chief of quality, but did not receive the promotion. The candidate who was ultimately hired had not sought the position and allegedly lacked the minimum qualifications for it. The department circumvented its own internal procedures to promote the candidate, meaning that she was not only passed over for the promotion, but the Ohio Department of Youth Services, which I should mention is a government entity, it went around their own internal procedures and instead promoted a lesbian woman who did not even apply for the job and didn't even meet the minimum qualifications for the job. From there, though, it actually got worse for Marlene. Quote, subsequently, the department took the program administrator position away from Ms. Ames and allowed her to choose between termination or demotion. The department then installed a gay man as program administrator, even though he was not qualified. And so that was the situation according to Marlene, that she was passed over for a promotion and then replaced altogether because she was not gay. Now, whether that's true or not is hard to say. The state of Ohio defended their actions by saying that she was passed over because even though she had the technical experience, she was a difficult person to work with, while Marlene maintained that it was because she was heterosexual. Regardless, though, that part doesn't really matter why she was let go, because the legal issue at play was a bit different, and I'll explain why in a moment. You see, Marlene filed a lawsuit against the state, arguing that she was unlawfully discriminated against. Specifically, quote, Marlene Ames sued the Ohio Department of Youth Services under Title VII of the Civil Rights Act, which prohibits sex discrimination in the workplace after a lesbian woman obtained a promotion she had applied for. She was later demoted, and her old position was taken by a gay man. However, Marlene's case ran into a challenge, which was the fact that being a heterosexual in this particular case meant that she belonged to the quote-unquote majority group. And therefore, when her case got to the Sixth Circuit Court of Appeals, the court imposed a higher standard on Marlene compared to if she was a member of a minority. You see, under the legal doctrine that the Sixth Circuit was using, a plaintiff that comes from a majority group who brings forth a Title VII claim must demonstrate not only the usual elements of discrimination, like for instance being qualified for a job but still getting rejected, but also the majority person must present additional evidence of background circumstances. Basically, they need to show additional evidence which shows that her case had the, quote, rare employer who discriminates against members of a majority group. Basically, if Marlene was a minority, all she had to do was to show the court that she was passed over for a job that she was qualified for, and that would be it. But because Marlene was a member of a majority group, she also had to show that this was part of a broader anti-straight pattern of bias. Because she wasn't able to do that, the Sixth Circuit Court of Appeals essentially said that she didn't have a case. However, Marlene appealed that decision all the way up to the U.S. Supreme Court, arguing that this wasn't fair, that this legal standard basically created a two-tiered system of justice depending on which caste you belong to. And eventually, the U.S. Supreme Court took up her case, they heard both sides of the argument, and they ruled in her favor. Specifically, in a 9-0 unanimous decision, the U.S. Supreme Court ruled that it's unfair to add an extra legal burden only to some people in these types of employment discrimination cases. Writing for the majority of the court, you had Justice Ketanji Brown Jackson write the following, quote, "A plaintiff who is a member of a majority group must also show background circumstances to support the suspicion that the defendant is that unusual employer who discriminates against the majority. We hold that this additional background circumstances requirement is not consistent with Title VII's text or our case law construing the statute." Then, going further and explaining the rationale a bit more, she outlined how both the text and the meaning of the law addresses individuals rather than groups. Quote, "The Sixth Circuit background circumstances rule requires plaintiffs who are members of a majority group to bear an additional burden at step 1. But the text of Title VII's disparate treatment provision draws no distinctions between majority group plaintiffs and minority group plaintiffs. The provision focuses on individuals rather than groups, barring discrimination against any individual because of protected characteristics. Congress left no room for courts to impose special requirements on majority group plaintiffs alone. This court's precedents reinforce that understanding of the statute and make clear that the standard for proving disparate treatment under Title VII does not vary based on whether or not the plaintiff is a member of a majority group." And then, summing it all up, she wrote the following, quote, "Title VII does not impose such a heightened standard on majority group plaintiffs. Therefore, the judgment below is vacated and the case is remanded for application of the proper standard." All right, just to pause here for a super quick moment, I'd like to introduce our longtime sponsor, Patriot Mobile. They are a great company who has for years now bridged the gap for Americans who want great cell service, but who also believe in faith, family, and freedom. And so here's a question. Have you switched to Patriot Mobile yet? And if not, well, consider doing so. You'll get exceptional nationwide coverage because unlike most other cell phone service providers, Patriot Mobile utilizes all 3 major U.S. networks. And so by switching today, you'll not only be working with a company that actually supports your values, but you will not be sacrificing quality or service. They can even add 2 numbers on 2 different networks on one single phone. So it's like carrying 2 phones in one if you need that type of thing. They have unlimited data plans, they have mobile hotspots, they have international roaming, they have internet on the go devices, internet backup. Also, switching is super easy. You can keep your phone, you can keep your number, or you can upgrade. Either way, their customer service team is based 100% in the US, and so it's easy. You can get up and running in minutes. And best of all, switching to Patriot Mobile supports your values. If you believe in the First and Second Amendments, if you believe in the sanctity of life, in supporting our veterans, well, this is where you belong. And so head on over to patriotmobile.com/Roman or call 972-PATRIOT. You can get a free month of service if you use the promo code Roman. So switch today, go either to patriotmobile.com/Roman or call the number on your screen. I'll also throw everything down into the description box below. And again, if you use promo code Roman, ROMAN, you can get a free month of service. And as such, Marlene's case has now been returned back down to the lower courts where she can actually argue about whether or not she was really discriminated against. Because up until now, she has literally just been battling the court system about whether or not she can bring her case forth. And as you would imagine, Marlene's legal team was thrilled with this new development. In fact, one of her lawyers was quoted as saying the following after this ruling came out, quote, We're pleased that this is the end of quite a long journey. This was a major legal hurdle in front of her. This is something she is incredibly pleased about. And then likewise, Marlene herself was quoted as saying the following: "When I filed a discrimination claim, I didn't know that my burden was going to be harsher than somebody else's burden to prove my case. I want people to try and understand that we're trying to make this a level playing field for everyone, not just for a white woman in Ohio." And indeed, just as she said, that's the real key takeaway here. With the Supreme Court ruling now in place, people across the whole country who feel like they've been discriminated against by these DEI policies can now go ahead and bring cases forward without having that additional legal hurdle to jump through. Moving forward, even if you happen to be a straight white man, if you feel like you were discriminated against in the workplace or in the hiring process, you can now bring forth your case without having to additionally prove that what you experienced was part of a larger pattern of discrimination. And as The Guardian notes in their analysis, this comes at a time when these lawsuits are really beginning to stack up. Quote, "The case comes amid broad-based attacks from the federal government under the Trump administration's campaign against diversity, equity, and inclusion policies, or DEI, in American society, which has become a powerful flashpoint among conservatives in recent years. Over the last 2 years, dozens of cases that aim to dismantle DEI policies in the workplace have flooded courts around the country." And I'll mention that article was from several months ago. It's probably at least hundreds of cases by this point. And so there you have it. If you'd like to go deeper into the Supreme Court ruling for yourself, I'll throw a link to the PDF version of it. You'll be able to find it down in the description box below this video if you're the type of person that likes to dig into the weeds. And all I ask in return is that as you're making your way down there to the description box, if you haven't already, take a quick moment to smash that like button so that this video can reach ever more people via the YouTube algorithm. And also, if you like this video, we have plenty of other videos you'll like as well, and in the future, we'll have many more videos you'll probably like as well too. So hit that subscribe button if you haven't already. That way you can be informed of any new episode as we publish it. And then until next time, I'm your host, Roman from the Epoch Times. Stay informed, and most importantly, stay free.